lot of times I meet these lawyers and they're going to every seminar, reading every book, every little trick, but they're not getting in the ring.
Theory will only get you so far. To become a top trial attorney, you have to roll up your sleeves and hone your skills in the courtroom.
I think you just need reps. You need to get hit in the face. And there's really no substitute for that.
You're listening to Personal Injury Mastermind, the show where elite personal injury attorneys and leading edge marketers give you exclusive growth strategies for your firm. As CEO and lead trial attorney of the largest personal injury firm in San Diego, John Gomez knows how to take control in high-stakes legal environments. Since 2005, Gomez Trial Attorneys has secured more than $750 million for their clients and a multitude of 7 to 9-figure wins. I caught up with the 11-time San Diego Outstanding Trial Lawyer to learn what it takes to become a top-performing trial lawyer. I'm your host, Chris Stryer, founder and CEO of Rankings.io. We help elite personal injury attorneys dominate first-page rankings with search engine optimization. John was back on the show in June 2020. To anyone that hasn't listened to that episode, you absolutely should. We covered a ton of ground surrounding his journey to success and the business side of Gomez Trial Attorneys. This time around, I want to focus on strategies for trial. I asked John how lawyers can get hands-on experience in the courtroom.
There are less and less opportunities now to try cases. It's obviously very risky, very expensive. And so a person that is trying to break into the game, I would suggest either doing some criminal cases, plenty of trials over there all the time. But if you can't do that, then I would highly recommend just hitching on with someone that has more experience trying cases than you do. Maybe you have a case that could be tried. I would not suggest doing that first one by yourself or the first 5 by yourself. Or you see this lawyer that you admire and you might just say, might there be an opportunity for me to hang out with you and work with you in a trial? And a lot of people will come to me and say that. I'll do it for nothing. I just want the experience. That's
a great piece of advice. And I know there's tons of courses and books. Is it get the experience and then dive into the books for the extra little nuggets? Like, is that where you start? Is the shadowing and the mentorship if you can't try some of those cases yourself at the beginning?
There's so many book trial lawyers out there or seminar trial lawyers out there that are theorists and haven't really, gotten in the ring themselves, And so I've always thought develop a basic understanding of evidence and then get in there and do some trials, whether by yourself or shadowing someone. And then you can take it to the more refined or theoretical level. A lot of times I meet these lawyers and they're going to every seminar, reading every book, every little trick, but they're not getting in the ring. I think you just need reps. You need to get hit in the face. And there's really no substitute for that.
That's a great piece of advice. So let's talk about the mental preparation. What kind of mindset do you have to become this preeminent trial attorney? Because it is not a 1 year you're done.
Yeah, I think it's really a mindset that can transcend trying cases. And that is always re-examining, always looking inward, always trying to get better. Especially in this business, you're only as good as your last trial. Like my colleagues have a very short memory. And so, I lose a trial, that's all they want to talk about. Oh, Gomez lost a trial. And they don't remember then I won the 6 before that. And that's fine. I don't have any problem with that, but it's reality. The more important lesson is that in anything we do, we always have to be re-examining, getting better, sharpening our tools. Like if you were doing the same SEO stuff you did like 5 years ago, you'd be getting blasted, you'd be out of the market. Some trial lawyers try the same case today they tried 20 years ago, and that's no good.
Yeah, you got to innovate. You got to mix it up and learn from your mistakes. So a case is going to go to court. What goes into it? Do you do mock trials? Are you reviewing the defense? Like what goes into that kind of the preparation before you even step in to kind of take on that battle?
Before the case begins, we're going to have a very sort of robust discussion and examination of what story we want to tell. And so that will take place in phases. Initially, we're going to have an idea. How do we want to tell a story? What are our themes? What are our analogies? What are we going to emphasize? Most importantly, how are we going to deal with the problems in the case? How are we going to make those problems our advantages? You really just have to think long and hard about how you want to frame the case and deliver the case and tell a story. At that point, we will engage some focus groups to help us refine that, because a lot of times we become very tunnel vision and big, we get so used to the case and we have our ideas about the case, and we're really not human beings. We're weirdos, we're lawyers. And so then you show the case to some human beings and they come up with completely different, stories or ideas or themes or analogies. And so it's an evolving process. We have our ideas, we do a focus group, we get some new ideas, we talk about it some more, we do another focus group. And so it's kind of this developmental process where you're just throwing stuff on the ground, starting over, throwing stuff on the ground, starting over until you get to a point where you're pretty comfortable going into trial that, here's the story that's going to be most persuasive and here's the likely outcome.
On that story side, have you found that since you've got a lot of reps, right? You've hey, I've took this story angle and it worked really well. And here's kind of a similar case. Is it those types of scenarios too, that you're applying and refining the story?
It's easier to do it the 60th time or the 70th time than the first time, because you have context and experience. And so oftentimes the same general story is told time and time again. And so the same themes, may be told or expressed time and time again. And so, yes, yeah, you're absolutely right.
So are there any of a few analogies, like when you're going to explain something really complicated that you go to that really seems to resonate with the jury?
I just look for something that the ordinary person can relate to their life. We teach our kids, right, to look both ways before they cross the street, because you always have to be, aware of and make sure that there's not going to be something bad that happens, and likewise here, this driver is driving a 30-ton cement truck and needs to look both ways before they enter an intersection. And, who knows, I just made that up. But, you always want to just relate it to something in the common juror's life. And if it's kind of a non-controversial thing that kind of governs how we live our lives or what we value, then it's easy for them to make that leap to the conduct of the defendant.
During these mock trials, what goes into the jury selection and the story on that side?
In the focus group part of things, in the mock jury part of things, we're trying to put together a mock jury that basically replicates what we expect to see in that jurisdiction. And so different places obviously have different types of people, and different places have different, values. Trying a case in San Francisco is going to be a lot different than trying a case in the Deep South, for example. So if I was trying a case in the Deep South, I would want to go get mock jurors from the Deep South and do my focus groups in the Deep South, whatever the Deep South means. And within even the South, I would imagine folks in Tennessee or Mississippi think differently from folks in Southern Alabama, so I would want to drill down, to that level and be bouncing my ideas off people, with those values and experiences.
Understanding the jury allows lawyers to create compelling stories. I want to know how great trial attorneys explain that story to the jury.
I think we need to understand that we are communicators. And so we need to communicate purposefully and in purposeful ways. Sometimes tone matters. Sometimes pauses matter. Sometimes, where you're standing matters. You can say, on the one hand, Harry said X, but then James, and you move, to another, and James, just to allow the jury in their mind, it's very easy for them cognitively to separate those two concepts. And if you are moving to different spaces, and so you've got tone, you've got pause, you've got space, and then obviously, we have visuals usually that we're using to make the point while we're talking.
When I'm doing interviews at our company and I interview and they're sitting in the same seat and they all just kind of blend together.
Yeah,
and
right.
I can kind of see the different people when you change the tonality and your different placement of where they're at. Like, it kind of helps with me to understand the different viewpoints.
Yeah, it makes it's just easier for the brain to process,
Right there. I think I said this on a previous podcast interview where you've had that statement where the guy says, I didn't say the neighbor killed his wife. I didn't say the neighbor killed his wife. So you're using the different words. And
yeah.
There's this book, Influence, The Psychology of Persuasion, by Cialdini. And one of the principles, it talks about reciprocity, right? So when you go to the car dealer, first thing they're doing right when you go in to look at a car is they're handing you water, they're trying to get you food, they're building up all this reciprocity so that, you buy a car. Is there anything like that where you're trying to get the jury on your side that's actually above board? I'm sure there's probably constraints and things that block this, but what kind of things can you do to get that reciprocity?
Yeah, we can't give them cookies or water or anything.
Right.
Or, popcorn, but what we can do is respect their time. I think that's really important. You'll see a lot of lawyers are very disorganized and waste time. I try to be very, very expeditious and organized and efficient in everything I do. My counsel desk will be very clean, uncluttered. I'm setting up before the witness gets in. I'm not fumbling through stuff. I'm getting to the point and getting done. And, that's one thing, obviously, that I think the jury appreciates is if you don't waste their time. I mean, that's a pretty basic thing, but a lot of lawyers do waste their time. And I think a more organized, efficient lawyer that doesn't waste their time, they appreciate that. And I would extend that to, get to the point and sit down and shut up. Less is more, especially, with today's generation. I mean, we're not the Clarence Darrow generation. We're going to sit there and listen to some guy talk for 5 hours. We want to get in, get out, and be done.
Right. On that composure side that you're talking about, not cluttered, prepared, when the judge comes in and you've had those reps, can you tell it like they recognize you when they address you? Is that something the jury can pick up on? Like the judge knows this individual, so obviously this individual has experience and this isn't his first, Well,
I think like judges will attempt not to convey that. Like, oh, I know Gomez. Always good, being in front of you, Gomez. Who are you, sir? No, they're not going to do that. But I think what happens is over the course of the trial, the same things that will annoy the jury will annoy the judge. And so the judge may express annoyance at the counsel that's annoying them. And so then you're building up some goodwill probably with the jury through the judge. And otherwise, or you're just bright, like the other side's making dumb objections, and the judge is overruling them. Like, I think that is lending some trustworthiness or credibility to the good lawyer. Hopefully me.
Pre-trial preparation, managing witnesses, and building reciprocity with the judge and jury by respecting everyone's time is great advice. I wanted to know what makes a strong and memorable opening statement.
I try to do sort of talk in threes, all the time. I really like the rule of threes. I'll give original credit. There's a lot of people that believe in threes, but Mark Lanier in particular is very focused on the rule of three. When I give an opening, there will be 3 chapters to the story always. Within, the chapters, there will be subparts that are threes. 2, there's always going to be an accompanying presentation. I like to use different media, so I'll be doing some drawing, I'm sure. I'll have the PowerPoint. I may have some live stuff, usually like a model or whatever, something I can hold in my hand. So I'm varying the modes of delivery, right? I'm talking in threes, and I'm getting to the point. I don't want a long opening. I'm hopeful I can get that thing done in like the 40-minute region, sometimes less. There's great trial lawyers that differ, but man, if I'm going over an hour, I feel like that's way too much.
Yeah, you start to lose their attention. What about your expert witnesses? You're selecting your expert witnesses, and is there preparation that goes into them and their delivery? Like, how critical is it to get these expert witnesses that have a lot of reps as well, right? Because a lot of these are very expensive, and especially on the med mal side, what goes into that?
Yeah, that's a hard thing, because a lot of these expert witnesses feel like, we can't really tell them how to do their job, or they've testified a bunch and they don't want to be coached at all. Like, they know better than us. And sometimes that's fine. You will have worked with this expert before, what they're going to sound like and look like, and essentially what they're going to say. But if I've got a problem, like if I have an expert that, for example, doesn't speak up or articulate, then I'm going to have a conversation with that expert in advance, and we're going to practice. I have my own courtroom. We'll bring them in and make them practice and get better, because the body of knowledge and the facts that expert are going to relate is such a small part of whether or not the jury's going to like them or believe them, or where they went to school, whatever. A larger part is how they tell the story, and like we talked about before, analogies, I want to get them talking in analogies. I want to get them relating what they have to say to common everyday life and values. And so I would say, don't be afraid of or intimidated by an expert witness. It's your game, your show, and you're allowed to coach them up however you want.
Absolutely. When you're telling this story, you're trying to get as much value to build up the case value as much as possible. But does the story kind of have a trajectory where it touches on each of these? Is that like one of the main components?
Yeah, so at least in California, we have a variety of things that are compensable as non-economic damages, things like pain and suffering, loss of enjoyment of life, anxiety, grief, humiliation. And so, yes, we would try to sort of address each of those types of things, but it's always going to be in stories. It's never going to be through the plaintiff. The plaintiff is not the person I want up there talking about how terrible their life is and how rough it is and how bad this hurts and that hurts. I want other people that know that person. I want them telling the story of the loss and the damage. So our person looks more like a hero than a whiner. You never want to have a whiner. You want to have a hero. I'll have short witnesses that are kind of before and after witnesses that will just tell a story or two about how Chris is different now, than he was before.
I can't help it but I relate everything to like marketing. And it makes me think of like a website where you're trying to convey different types of social proof, and where one individual says, hey, I'm this expert, let's just say trial attorney, and then you have a testimonial where it's someone else saying it, then it carries more weight. And then you have a case study and actual result, that you go over. And then you have, an accredited big name association saying it, it carries more weight. And that's kind of how that makes me feel. And I never even thought of that. I just saw actually yesterday, John, I was on TikTok. I was looking at the attorney category, and the plaintiff was on the stand talking about how she couldn't move her arm, and then her phone rang and she jerked back and grabbed the phone.
That'd be a bad day in court.
You told your story, you're summarizing it. What goes into a fantastic closing argument?
I think, what I'm going to do is borrow a lot from the opening, and particularly the presentation stuff, and demonstrate to the jury that we proved what we said we were going to prove. So we have some consistency, and then we have credibility. So a lot of what you'll see in my closing is the same stuff you saw in the opening, and then on top of that, we're going to layer in a little bit more. You're going to see writing, like drawing and filling in the verdict form. We get verdict forms, right? And ultimately the job of the jury is to fill out the verdict forms. And ultimately the point of the closing argument is to provide them guidance how to fill out the verdict form. And so, I'm going to fill out the verdict form, on an overhead projector. And then, to provide them that guidance, I think, seeing a person write it really opens up cognitive pathways for the jury, makes it easier for them to accept that and model that. By each answer, we're going to put 3 reasons why. We're always going to go back to that 3. Once I get into the damages part of things, or the human suffering, I'll tend to just step into the space a little more, step away from the template stuff and the presentation stuff and the writing stuff. I just tend to let myself have a little more emotional sort of connection with the moment and the loss and the jury. And so that's going to be a different mode of presentation as well. Have a more human connection with the jury. So you're varying modes, you're varying, tools, you're varying tone, and hopefully all that stuff together will be an effective and persuasive message.
I love how John walks the jury through the verdict card while tuning into the human element. And John has more than one insight to offer PI lawyers who want to become great trial attorneys.
A lot of lawyers that try cases don't take the time or make the effort to know the rules. And, I liken it to an NFL football game. And, you see the coach on the sideline and, they're throwing challenges and this and that. And it's way more than that. You got to know the rules way more than that, because it's really a case in which you're watching the football game and you got to make the calls. If you don't call the penalty, then there's not going to be a penalty. Imagine if the referee's job was just to listen to you call penalties and see if you're right or not, right? And so I would say, holding, number 72. And then the ref would be, okay, you're right, holding 72. Or the ref might say, no holding there. If you know the rules, you control what evidence comes in, you control what evidence is excluded. And if you know the rules, you have a tremendous advantage over a lawyer that doesn't know the rules. And so I would say, just pick up the evidence code, pick up the code of civil procedure, really, really get to know those rules, because there's a lot of little nuggets in there that a lot of lawyers never become aware of.
That's a great piece of advice. That makes me think of competence builds confidence too. And I love relating it to sports as well, because that's something that a lot of individuals can understand. And that's fantastic.
Always sports.
Yeah. And John, if we have a PI attorney that's listening, they got a great case, they're looking for co-counsel and want to run it by you, what's the best way to get in touch with you? What would you recommend to them?
Yeah, you can text me at 619-850-2813 or email me, John, JOHN, at thegomezfirm.com, or just look me up, on the website and you'll see it there. Trial lawyers that enjoy trying cases will always talk to you about your trial. And that's me. I've talked to a ton of people about trials, and I always find it satisfying to help other trial lawyers get the good result that our clients deserve.
John delivered a heap of actionable advice for building strong cases that win multi-figure verdicts. Before the trial, think long and hard about the story you want to tell. Consistency is king. Practice that story on a mock jury, then bring that story to life in court using PowerPoints, models, witnesses, and movement. Finish strong by walking the jury to a logical conclusion where the verdict helps rectify the client's suffering. But I think the most important lesson here is to get in the ring as often as you can to improve your skills. I'd like to thank John Gomez from Gomez Trial Attorneys for sharing his story with us, and I hope you gained some valuable insights from the conversation. You've been listening to Personal Injury Mastermind. I'm Chris Dreyer. If you like this episode, leave us a review. We love to hear from our listeners. I'll catch you on next week's PIM with another incredible guest and all the strategies you need to master personal injury marketing.